Today, in the continuation of the above video, we are going to see the characteristics of the company. There are different types of characteristics. First one is incorporated association. Second one is legal personality. Third one is perpetual succession. Fourth one is limited liability. Next one is transferability of shares. Next one is common seal. The next one is separate property, and the last one is separation of ownership and management. Let us see one by one in detail. The first one is incorporated association. A company must be incorporated or registered under the Companies Act with minimum number of members required for this purpose is 7, and which in case of a public company it should have at least 2. It should have 7 members, and in private case it should have 2 members. Next one is legal entity distinct from its members. Unlike partnership, the company is distinct from the person who constitutes it. Hence, it is capable for enjoying rights and of being subjected to duties which are not same as those enjoyed or borne by its mistakes. Next one is factors. The factors which includes are factor of case, which is separate legal personality of the company is the bedrock of the company law. It is an example which held in the SE of India Private Limited versus EID Parry of India Private Limited in 1998. The case is run in the Madras. The next one is artificial person. The third characteristics. The company, though a juristic person, does not possess the body of nature being, it exists only in the contemplation of the law. Being an artificial person, it has to be depend upon natural persons, namely the directors, officers, shareholders, etc., for getting its various works done. However, these individuals only represent the company, and accordingly, whatever they do within the scope of the authority conferred upon them and in the name of on behalf of the company, they bind the company and not by themselves. The next feature is limited liability. One of the principal advantage of trading through the medium of limited company is that the members of the company are only liable to contribute towards payment of its debts and to a limited expenses. If the company is limited by the shares, the shareholder's liability to contribute is measured by the nominal value of the shares he holds, so that once he or someone who held the shares previously has paid that nominal value plus any premium agreed on the shares were issued, he is no longer liable to contribute anything further. However, companies may be formed with unlimited liability of members, or members may guarantee a particular amount. In such cases, liability of the members shall not be limited to the nominal or face value of their shares and the premium, if any, unpaid thereon. Next one is in case of unlimited liability companies, members shall continue to be liable till each paisa has been paid off. Next one, in case of companies limited by its guarantee. If it is limited by the guarantee, the liability of each member shall be determined by the guarantee amount. That is, he shall be liable to contribute upon the amount guaranteed by him. The next one is if the guarantee company also has a share capital. If it has a share capital, the liability of each member shall be determined in terms of not only the amount guaranteed but also in the amount remaining unpaid on shares held by the member. The next one is unlimited liability of a member of a limited liability company. According to section 3A inserted by the Companies Amendment Act 2017, which provides that at any time and a numbers of member of a company is reduced, in case of a public company, below 7, and in case of private company below 2, the company carries on business for more than 6 months, while the